This lesson focuses on negligence. Within this lesson, we will discuss the elements of negligence, including duty, breach of duty, factual cause, scope of liability, and damage. We'll discuss defenses to negligence based in common law, contract law, and statutory law, and we'll also talk about legal remedies for a negligence complaint. Let's first start by talking about the elements of negligence. Now, in thinking about the history of negligence as a law, it actually emerged through common law, through a lawsuit that was filed back in 1850. So our interpretation of negligence has come about through case law. And negligence falls under the broader umbrella of tort law. You'll see on this slide that a tort is any wrongful act. It can be incidental or intentional, from which injury occurs to another's person or property, for which the courts can provide a remedy for that injury. Now, negligence is an unintentional tort. So it is an accident that caused injury to another person in the form of physical injury, property loss, or reputation. Negligence essentially is caused by one's failure to use care as a reasonably prudent and careful person would under similar circumstances. And your failure to act reasonably and carefully led to someone's harm or injury. There are two primary forms of negligence. There's an act of commission and an act of omission. Now, an act of commission is something that one did that they should not have done. So it is the act that caused someone harm. An example of an act of commission might be an athletic trainer providing treatment to an athlete without their consent, and that treatment caused them injury. So that would be an act of commission. And then an act of omission is the failure to act. It's something that one should have done to protect another from harm, but did not do. So, for example, a coach sees an athlete show symptoms of a possible concussion, but allows them to continue to play. That is an act of omission because they should have pulled that athlete from the field, but they chose not to. When considering what elements of negligence a plaintiff must prove to win a negligence complaint, there are 5 that are outlined in our text: duty, breach of duty, factual cause, and scope of liability, and damage. Sorry, the 5th one. Now, I wanted to point out that when looking at legal texts and interpretations of negligence broadly, the 4 most common elements are duty, breach of duty, factual cause, and damage. Our text just happens to also talk about scope of liability, which is a focus on foreseeability. But we're going to go through each element so that you know what constitutes negligence and what a plaintiff would have to prove in a court of law. Let's start off with the first element of negligence, which is duty. Now, duty is essentially one's responsibility to exercise reasonable care in your actions as to not cause someone harm. So, especially when your actions could create an unreasonable risk of harm, it is your responsibility to act as a reasonable, careful, prudent person would, so that you don't cause harm to another person in terms of their physical body, their personal property, or their reputation. Now, the type of duty that you owe to another depends on a number of different factors, such as the nature of the activity. For example, high-risk sports are going to require a much greater duty from those who are administering the sport or coaching the sport. It will require greater supervision. It will require greater training and qualifications compared to low risk sports. The nature of the participants will also influence the duty that is involved, such as, are you working with youth participants? Are you working with adults? Are you working with individuals who have special needs? That will influence uh, what responsibilities you have to keep that particular person safe. Other considerations are the nature of the facility. Your duty will change whether you are working in an indoor facility or an outdoor facility or underwater, for example. Uh, the responsibility that you have towards another, it would change based on the location and the facility. So some examples of duty for you are the duty to warn of dangers or risks involved in an activity, a facility, use of equipment, the duty to supervise your program participants, the duty to instruct in sport. As a manager, you have a duty to hire qualified staff. If you are managing a facility, you have a responsibility to inspect the facilities and the equipment to provide a safe environment. If you are administrating sports programming, you have a duty to provide emergency care when an athlete gets hurt. So those are all examples of responsibilities that we have as sport managers. But those responsibilities will really change based upon the nature of the activity, like based upon the nature of your job. Now, duty, so this element of negligence, arises from a special relationship between the sport manager, who's the service provider, and we'll say the participant in this case, but really any stakeholder that you're working with. So, this duty, this responsibility, it arises out of a special relationship, which means that if you don't have a special relationship, you do not have the duty. You do not have this responsibility to another. So, an example of that might be a stranger does not have a responsibility to rescue another stranger from harm. There is no relationship between the parties, and therefore there is no duty. However, duty arises when a relationship is established. And a relationship is established in three instances, which we see on this slide as sources of duty. So there are inherent relationships in our field. When the sport manager has an inherent relationship with one of the key stakeholders. So an example might be a coach and an athlete, a manager and their subordinates. It might be a director and their employees. Those are inherent relationships where duty is imposed. On this screen, you'll see an athletic trainer with an athlete. Duty also arises out of voluntary assumption. So going back to my example of strangers, you don't have a legal responsibility to help someone else, but if you assume that responsibility, you then must show due diligence, be a prudent, careful person when engaging that individual. So when you voluntarily assume a duty, know that a special relationship is established, and that then creates an obligation that you will act with an appropriate standard of care. So in this slide, we see a picture of the athletes helping another athlete. And then a special relationship may also arise through statutes and regulations. And this is when there are laws that specify what duty is owed to another party, such as on this slide, you'll see the COVID protocols that are coming down through state guidelines and regulations that must be implemented by sport managers. Other examples might be laws that require an ambulance to be present at football games. So there are statutes that actually will outline what your duty is to your primary stakeholders. Now, Now that we know what establishes duty, so through that special relationship, let's talk about the amount of duty owed or what type of duty is owed. And that's really based upon standards of care. So the reasonable person duty, the standard is applied to society in general. So this is just thinking of an ordinary person, and the court will consider what care would an ordinary person have provided under similar circumstances? Or how would an ordinary person have acted in a similar situation? And as long as you provide reasonable care, you act reasonably, then you meet this standard, this duty. Now, under a reasonable person, you don't have a duty to rescue another person that you don't have a special relationship. It's basically in your day to day, make sure that your actions aren't harmful to someone else. And then there's special relationships. So this standard is applied to those with a special relationship, such as the inherent relationship that we talked about. So those with a special relationship, you have a duty to provide care that is to the level of your skill, knowledge, and ability. So, for example, a parent helping a child, they will be able to provide care based upon, their knowledge base. However, compare a parent to a physician, that knowledge is very different. A parent to a coach to just a supervisor. The skill, the knowledge, and ability will be taken into consideration when courts discern what level of care should you have provided. On this screen, we see a coach with an athlete. So you need to uphold the standards of your profession. And then we have a professional relationship, which is a higher level of care. It's the highest, actually. This standard is applicable uh, to trained professionals, so coaches, teachers, athletic trainers, physical therapists, employers, sports agents. The level of duty owed is much higher of a level than a reasonable person, and you are expected to uphold the training, knowledge, and skill of your profession. And so, yeah, the level of duty that is owed is really based upon your relationship with the other party, as well as your skill, knowledge, and ability. So that's the first element of negligence is duty. Now, the next element is breach of duty. And if you focus on that word breach, it's really just the failure, right? The failure to fulfill that duty that is owed to another party. So it's a failure to exercise reasonable care, failure to act as a prudent person would under similar circumstances. And that failure can be through the act of commission or act of omission that we had discussed. Now, when determining breach of duty, the courts will try and determine, all right, how much risk was did the service provider, so the sport manager, expose their patron or participant to? What is the category of risk? Because sport managers are generally responsible to protect individuals from harm, but sport is such a risky activity, and so the courts actually categorize the risk first. An inherent risk are risks that are integral to the activity. They are risks that, if removed, would essentially alter the nature of the sport activity. So, for example, tackling in football, can that lead to physical harm? Yes, it can. But can you remove tackling from football? No, because it would completely change the nature of the sport. It then becomes flag football, which is a completely different activity. So there are some risks in sport and in business that are just integral. They're inherent to the nature of the activity, and they cannot be removed or eliminated. And in general, a sport manager or a service provider has no duty to protect another from the inherent risks of an activity, because like I said, they're inherent, they can't be removed. And then there's ordinary negligence. Ordinary negligence means risk that is above the inherent risks of a sport or activity. So I wanted to give you an example of this. Here is a YouTube clip, but I think I need to go to the actual website. So let's check out this YouTube clip. This would be an example of ordinary negligence.
Trying to get to the corner, won't get there. Excellent speed by Damon Arnett. Abram is down, I believe. He hit the cart over there. He was running full speed after he got him out. Wow, this is scary. Jonathan Abram suffered an injury in the opening Monday night game a year ago back in Oakland and was lost for the entire season. Suffered a torn labrum and rotator cuff in his NFL debut. Played last week, here early, just his third NFL game. We'll be right back. We'll show you what happened, but here's the play. Gets a piece and then spills into Sarah Thomas and then into the television cart there.
What a great effort play. And those guys run as fast as they can, given their body.
All right, let's go back to our PowerPoint so we can talk about why that is ordinary negligence. So that is an example of ordinary negligence because, yes, football players are expected to be exposed to physical risk in their sport, but is running into a television or media cart, is that an expected risk of football? Could that cart have been moved a little bit farther outside of the boundaries of the field of play to avoid a risk to that athlete? In this particular instance, the service provider would be responsible for increasing the risk to the athletes by putting that cart in such close proximity to the field. So ordinary negligence is when a sport manager or service provider increases the risk, unnecessarily increases the risk to another through their action. And then there's aggravated negligence. And this is a much more extreme departure from reasonable care than ordinary negligence. Often with aggravated negligence, it gets to the point where it almost seems like someone was intentionally trying to harm someone. We'll see terms like gross negligence, reckless misconduct, willful and wanton conduct. It essentially means that someone acted with complete disregard for the safety of another person. So that's a much greater departure from reasonable care. So they're going to look at what is the category of risk, because like I said, a sport manager is not responsible for inherent risk, but they would be responsible for ordinary and aggravated negligence. And then they'll look at what is reasonable care. So going back to that previous slide of standards of care, they're going to consider the sport management or sport manager's skills, their knowledge, their profession, to have a better idea of what a prudent profession or professional in their field, how they would have acted in similar circumstances. And then the courts will also ask, was the risk foreseeable? So this is where scope of liability comes into play, because truly a sport manager can only reduce or eliminate risk if they can actually foresee it. So could you see this as a possibility when putting that cart, right next to the field? So that's breach of duty, which is our second element. And we can move on to factual cause, also referred to as proximate cause, which is our third element of negligence. And so once a court has examined the duty of the defendant, and then they consider the breach of duty of the defendant next, the court will determine whether the breach of duty was in fact the cause of the injury. So it is the plaintiff's job, it is their burden of proof to show a direct relationship between the breach of duty and their injury. Essentially, would their injury have occurred had the negligent act, so the breach of duty, never occurred. Now, there are different rules upheld by different jurisdictions, which I find quite interesting. And the probable consequence rule is often called a but-for test. So, but for the breach of duty, the injury would not have occurred. That would mean proximate cause. So if there was not a breach of duty, the injury would not have occurred. So probable consequence really relates to like actual cause and effect. Think about that. And then substantial factor test, which Ohio law follows, will actually consider whether the defendant's action was a substantial factor among several other factors that caused the injury. There may have been a chain of events, but if the defendant was a significant contributor to the injury, then they can still be held liable. So for example, a facility that is understaffed and there's a particular area that is not monitored, such as a basketball court, and players get into a fight and the injured party sues the university. Well, did the university start the fight? No. But if there was a staff person there, they probably would have not allowed the conflict to get to a physical altercation. So that would be a substantial factor that contributed to the harm. And the fourth element of duty is scope of liability. So this focuses on the foreseeability of the harm. Could the defendant have foreseen a possible injury as a result of their action, so act of commission, or inaction, which is omission? Once again, a risk of injury must be foreseeable by a reasonable person in order for that person to be able to avoid it. So the courts will consider the foreseeability of the event. There's really no liability for an injury caused by an unforeseeable risk. So in golf, we'll often see acts of God, or really any outdoor sport. And could that act of God, a lightning strike, have been foreseeable, have been prevented? I don't know. I mean, I know advanced technologies out there. That's a whole nother conversation. But foreseeability is an element that will be discussed. And I love this graphic on this slide because foreseeability is the dotted line. You are expected to foresee the direct consequence of your action. You are not expected to see the rabbit hole trail of how your action affects another action, affects another action, and all the way down the line, someone accidentally gets hurt, right? So foreseeability is really, could you anticipate the immediate direct consequence of your action or omission? And then the last element of negligence is damage. And damage is a term that's used synonymously in a couple of different ways. So I wanted to distinguish these two. In this case, as an element of negligence, damage refers to injury, which means that the participant experienced some type of harm. So that might be economic losses, physical pain and suffering, emotional distress, physical impairment. They have to have been harmed in some way in order for the courts to provide a remedy. If there's no damage, there's no injury, well, guess what? There's no negligence, and therefore there's no compensation or remedy from the court. Now, courts will often also use damage as a term to refer to the monetary compensation that is awarded as a remedy for the wrongful act. And so if the plaintiff wins a negligence case, the court will award damages, which is typically monetary compensation in this case. And so just for clarity moving forward, I will typically refer to this fifth element of negligence as injury for clarity's sake. But we'll talk more about damage when we discuss the legal remedies to negligence. But once again, to prove negligence, the plaintiff must prove all 5 elements, all 5. So let's keep that in mind when we discuss viable defenses for the defendant. As a way to apply what you have learned, I encourage you to pause the lesson and review your mock trial case and work to identify the 5 elements of negligence for each of the 3 defendants. So from the plaintiff's point of view, use the affidavits to try and prove that each defendant was negligent. Okay, let's move on to the defenses to negligence. And those defenses come out of a variety of laws. So we will start off by talking about negligence defenses that arise from common law. So that's where they were created. And the first defense, and it is one of the best defenses, you will often see a defendant try and disprove one of the elements of negligence. So if a defendant can prove that one or more elements of negligence is not present, they will win the case. Once again, a plaintiff has to prove all 5. So duty, breach of duty, factual cause, scope of liability, injury, all 5. So the defendant, you just have to disprove one. You could disprove more, but it is one of the best defenses. Another major defense that defendants use is assumption of risk, which occurs when the victim becomes responsible for some portion of the risk of an activity. And as a result of assuming some portion of this risk, also assumes a portion of the liability for the injury. Now, there are 2 primary forms, or sorry, I used the word primary. There are 2 forms of assumption of risk. There's primary assumption of risk, and there is secondary assumption of risk. Now, primary focuses on inherent risk, and secondary focuses on ordinary negligence. And the graphic to top right of your screen is just an example of how we as individuals are responsible for the inherent risks of activities that we voluntarily participate in or engage. And so for primary assumption of risk, the plaintiff assumes the inherent risks of an activity, and as previously discussed, a sport manager is not able to remove risks that are inherent to an activity that cannot be eliminated without completely altering or changing the nature of an activity, right? So sport managers, they're not liable for injury that occurs from inherent risk. So the defense that they use is primary assumption of risk, that the plaintiff assumed the inherent risks of the activity when they knowingly and voluntarily engaged in the activity or participated. Now, for you to win a primary assumption of risk defense, the risk that has to be inherent to the sport. It can't be above that. The participant must have voluntarily consented to participate in the activity, and the participant must have known about the inherent risks of an activity. So they must be generally familiar, which means that if you're working with youth, you need to educate youth on the risks of an activity and how to safely engage, because they might not be familiar. Or novices, for example, people who are going to go bungee jumping or skydiving for the first time. As a sport manager, you are responsible for educating people about the inherent risks of an activity so that they assume those risks and take away liability from you. And then there's, and I also wanted to mention that primary assumption of risk can be established through implied conduct or expressed. So implied primary assumption of risk is usually evident by the conduct or actions of an individual. An individual participates in a sport. They play a game, right? A pickup game. Well, they're indicating voluntary consent by their conduct. And then there's expressed assumption of risk, where a participant is actually declaring verbally or in writing that they assume the risks of an activity. Typically, we see this established through waivers, where they sign an agreement that's saying, hey, I'm aware of the risks. I still want to participate. And then we have secondary assumption of risk. And this is when an individual accepts or assumes risk that is greater than that which is inherent to the activity. So you're assuming extra risk based upon your choices or your own conduct. And we often see these in 3 situations in sport. And so one is when a participant voluntarily participates in an activity when there is a substantial risk that the defendant will act in a negligent manner. A second situation is when the service provider has already been negligent and the participant takes part anyway. So essentially, as individuals, you are responsible for vet the people that you work with, like the programs that you participate in. Those participants are responsible for making sure that they're engaging with reputable service providers. Because if they go to a service provider who has a terrible rating, who's been sued a ton, who doesn't have the necessary qualifications, well, some of that liability is then put on the participant. In another situation, this is the one I see more common in sport, is when a participant fails to follow the rules or heed warnings in the sport activity. So you'll see on this screen, often in sport, we have do's and don'ts with behaviors. This sign you might see at a park, an outdoor park, where, hey, follow these appropriate actions. Don't do this, or else you might get injured. And if you don't uphold the rules or the policies of a program or even of your employer and you get hurt, you are liable for because of your actions. All right, a couple of more defenses based in common law. One is sovereign and governmental immunity. So immunity is essentially freedom from the liability to be sued. Now, sovereign or governmental immunity are judicial doctrines that prevent one from filing suit against the government and its political subdivisions without their consent. So it essentially protects the federal government from liability for negligence. However, it does not protect all of the government employees against liability. So the reason this is a defense is because if a governmental entity is sued for negligence, they can claim immunity. Hey, we have freedom from being sued because we act in the benefit of society and for public good. However, there is an act that came about, the Federal Tort Claims Act came out in 1946 because the courts essentially found sovereign and governmental immunity to be too broad and to provide too much protection to the government. And so this act removed the power of the federal government to claim immunity from a lawsuit for damages due to negligent or intentional injury by a federal employee in the scope of his or her work. So essentially, and we'll talk about the doctrine of respondeat superior in a minute, but essentially, if a government employee is found negligent while working within their authority and scope as a federal employee, then you actually can sue the government because something must be wrong and going on with how that employee is managed and supervised. Another defense is Ultra Vires Act. Oh, this is the one that relates to doctrine of respondeat superior. So essentially, an Ultra Vires Act is an act that is not within the authority or scope of an employee's responsibility. So it's when an employee acts outside of their job description, outside of their job qualifications, outside of the directives of their supervisors. They do something they should not have done. This is an act of commission. So they act outside of the scope of their job and someone gets hurt. When an employer, or when an employee engages in an ultra virus act, so they're once again acting outside of their responsibilities as an employee, then they are liable for their own conduct. That liability stays with the employee. And it's a protection for the employer. However, when the employee is acting within the authority and scope of their employment, they're fulfilling their job description, they are following the directives of their supervisors, and someone gets harmed. In that case, the liability is imputed to the employer. It's under the doctrine of respondeat superior, where an employer is liable for the negligent acts of an employee if the employee was basically doing what they were told to do, because then essentially the issue comes down to how the job was written, how the job was supervised and managed. It's more the employer who is at fault here. And then moving into contract law. So there are a few defenses based on contract law. And on this screen, we'll see a waiver of liability and informed consent. These are both contracts. I am anticipating that many of us have signed a waiver before. I love the example on this slide. It is from SMU, and this was a waiver that athletes were required to sign in order to participate in the midst of COVID. And you'll see right in the middle, so right here, when they're waiving and releasing SMU from all claims, liabilities, ... for any injury, loss, or damage due to contracting COVID-19. This is the waiver language. Essentially, it is a contract, and so for the waiver to be enforceable in court, it must follow contract law. So consideration is exchanged, and in this case, the participant, so the athlete, is relinquishing their right to file a lawsuit against another party. So this would be SMU in this case, in exchange for the right to participate. So they are waiving SMU from any liability for any injury that might occur due to SMU's negligence. So the athlete wants to participate and they're willing to waive those legal rights. Now this contract must be for the public good. So often waivers are enforceable in court, by the way. A well-written, properly administered waiver that is voluntarily signed by an adult can be used to protect sport managers from liability for ordinary negligence. The reason why I point out ordinary negligence is that for a waiver to be in for the good of the public, right, to follow public policy, it can't overreach. It can't be excessive. You can't waive your rights to file a lawsuit against aggravated negligence. The only thing that you are waiving liability for is ordinary negligence in this case. And then the parties must also have legal capacity to sign the contract, which just basically means that they have the competence to understand what they're signing. So they must be an adult or not under the influence of drugs or alcohol, or they must have the mental capacity to understand the contract. And then there is an informed consent. So this is also another formal contract. It's used often in sports medicine. We see it quite a bit. Or program interventions, physical therapy, athletic training, rehabilitation, but essentially the provider is asking the participant who's receiving treatment to acknowledge their understanding of the risks of the treatment and to waive liability in case they are harmed during the treatment. So these are ways to shift liability back onto the participant. A few other forms of contracts that are really great defenses for sport managers we see here are a facility lease agreement, equipment rental agreement, indemnification agreement. These are all great contracts. We're going to start in the middle of this slide just because our example here is an equipment rental agreement, which once again, we are trying to shift liability from the leaser, from the leasor, so that's the individual who is leasing out the equipment, to the leasee, the individual signing the equipment rental agreement. And I wanted to point out that you often will see, like we'll see right in this middle section, that in facility lease agreements, equipment rental agreements, often there is a waiver that's included. So we often see these contracts in combination. So here's a waiver that's talking about if you are injured based upon your use of this equipment, you are waiving Ohio State, in this case, liability for your injury. So equipment rental agreements are used to help protect the leasor, so the owner of the equipment and property. Facility lease agreements are trying to clarify who has liability for what. So typically in a facility lease agreement, all activity related injuries are the responsibility of the leasee. So whoever's leasing the facility will monitor and be responsible for all activities that they engage in. However, premise related injuries are often the responsibility of the leasor, so the facility owner. So if there are any structural problems or maintenance problems and someone is injured, that liability, even with a facility lease agreement, will still fall on the facility owner. A couple other documents. Now, an agreement to participate, this is actually not a formal document, or sorry, it's a formal document. It's not a formal contract. That's what I mean. It is a contract meant to strengthen the primary assumption of risk defense. So it is informative in nature. It's not contractual because no consideration is exchanged. The person signing the contract is just indicating that they are informed. They're not giving anything in exchange. They're not relinquishing any rights. So this document helps inform participants of the nature of the activity, any risks that they might encounter through their participation, and behaviors expected. So by outlining the risks, you are confirming that they know the inherent risks of the activity. That strengthens the primary assumption of risk defense. And then by communicating behaviors expected, you are strengthening your secondary assumption of risk defense, because if they don't uphold those behaviors, then that participant becomes liable. And then there's a few others. Indemnification agreement. This is one often we'll see in equipment rental agreements and facility lease agreements. I always like to think of this as a you broke it, you bought it clause, but essentially a party is agreeing to indemnify or reimburse the other party upon occurrence of an anticipated loss. Usually that's if equipment is lost, a facility is damaged, the leasee will be paying for it. It's a financial protection. Oops. Okay, going back here. And then lastly, independent contractors. I just wanted to make note that you will typically shift liability to an independent contractor. So when you contract out, the independent contractor then becomes responsible for themselves and for any injuries that might occur on the job. Your responsibility as the sport manager is just to make sure that you hire a competent and qualified independent contractor, and then also make sure that your premises are safe for them to work in. All right, there are a couple of defenses based in statutory law that I wanted to discuss. This slide I find so interesting. So comparative fault and contributory negligence relates to secondary assumption of risk when the plaintiff actually contributed to their injury. They did something to increase the risk to themselves, so they are partially at fault. Now, there's contributory negligence and there's comparative negligence. Historically, the courts used contributory negligence, and that was if a plaintiff contributed to their injury at all. Like I'm talking like at all. Like they did, let's see, an example of this might be a child who is swimming, I don't know, like a child who's swimming at the local YMCA and a parent, you know, isn't monitoring them for 5 minutes, right? 5 minutes, and a lifeguard isn't present, and that child is drowning, right? That parent is partially responsible, even though there should have been a lifeguard on duty. So under contributory negligence, if a plaintiff was at fault for an injury at all, they would receive nothing, which is pretty harsh. And the courts thought so too. So, in order to ameliorate the harsh effect of contributory negligence, a lot of states have moved to a comparative negligence system. So, contributory negligence was considered really harsh. So, states have moved to comparative negligence, which is a system of apportioning fault for the injury based upon how much the plaintiff was at fault and how much the defendant was at fault. And so under pure comparative fault, the award, it's honestly just a numbers game. So basically the award that is given to the plaintiff for the injury is just reduced by the percentage of fault that is assigned to them. So if the plaintiff is considered 60% at fault for the injury, they're still getting 40% of the monetary compensation of the award. If the plaintiff is 30% at fault, they'll get 70% of the award. So that pure comparative fault, think purely numbers. And then there's modified comparative fault. This is if a plaintiff is found substantially at fault, they will not be entitled to any of the award. And I'll give you an example of substantially. So here's a map of the states just to show that this is a state statute. Every state is different. And you'll notice here that Ohio State follows modified comparative fault. So if a plaintiff is substantially at fault, then they will not get any award. However, notice that we use a 51% bar. So substantially means the plaintiff has to be at least 51% at fault or higher. There are some states who use a 50% bar. I just find that kind of interesting. And then there are some states who use the pure comparative fault, the purely numbers. You just subtract the percentage of fault of the plaintiff from their award. And there are just a couple of states who still use that pretty harsh contributory negligence, where if the plaintiff, even if the plaintiff was 5% at fault, they would still not get an award. It's very harsh. So only a few states follow that. And then the last couple of negligence defenses based in statutory law, there are some that are legislation-based immunity. So once again, immunity is freedom from liability for being sued. And it only protects from liability for ordinary negligence, not aggravated. And here are a few examples that we see on this slide, and the pictures to the right illustrate these. There are Good Samaritan laws that provide immunity for people who administer emergency care to others. So for example, Ohio exempts all people who provide on-site care to victims of accidents, fires, explosions, near drownings, natural disasters. So it's a wonderful law. There's charitable immunity, which relieves charitable organizations from liability for negligence. And then there's recreational user immunity, and this protects landowners who are really gracious in opening up their property to the public for recreational purposes. So it protects the landowner from potential injury due to ordinary negligence on their property. And then there's volunteer immunity, which really protects volunteers at public, charitable, or nonprofit entities. What I hope you're noticing as a theme across these is that it's immunity for people who are doing public good, a public service. These are actions that the government wants to encourage, wants to protect, and therefore provides a certain amount of immunity to continue to encourage Good Samaritan, charitable, volunteer acts. And then the last defense is Procedural noncompliance, so shifting, going a different direction. Procedural noncompliance refers to the statute of limitations, and this was briefly discussed in the lesson on the introduction to the legal system. Essentially, a plaintiff has to have legal standing in order to have the right to file any lawsuit. And based upon the legal complaint, different legal complaints have a particular length of time in which the plaintiff has legal standing, so the right to file the lawsuit. So for example, in the state of Ohio, for a personal injury complaint, which we often see with negligence, the plaintiff has 2 years from when the injury occurred to file a lawsuit. And after those 2 years, the statute of limitations is up. They no longer have legal standing. And if they filed a lawsuit after 2 years, the defense could claim, hey, statute of limitations. And guess what? It's a very viable defense. And that lawsuit would be thrown out. Murder is the only crime that I'm aware of that does not have a statute of limitations. All other types of legal complaints have some type of limitations for how long you have to file a lawsuit. So what I would like you to do now is pause this lesson and go back to that mock trial case. And from the defendant's point of view, try and identify at least one element of negligence that is not present for each defendant. So try and poke a hole in the negligence complaint of the plaintiff. And then also consider the comparative negligence defense. How did the plaintiff contribute to their injury? The last part of this lesson is legal remedies. So this is if the plaintiff was able to prove all 5 elements of negligence. So they won the case. What happens next? Well, typically the court will, well, not typically, the court will provide a legal remedy. In most cases in tort law, we see the remedy in the form of monetary compensation. So damages in this case, which is the award, the remedy given, are typically compensatory, occasionally punitive, and seldom injunctive. So I just wanted to put that out there. Compensatory and punitive damages are monetary awards meant to compensate the injured party. Now, compensatory awards are essentially meant to specifically pay for the injury. So that might be a fee for medical expenses, property repair, lost wages, loss of property, loss of bodily function. It's really intended to make the injured person whole, but it focuses specifically on the injury and the cost of the injury. Punitive damages, on the other hand, go above and beyond compensatory damages. And it's essentially intended to punish the defendant and to deter that person and other people from acting in a similar manner in the future. So it's honestly, it's intended to cause the wrongdoer sufficient financial loss so that they will avoid such actions again in the future. It's pretty rare. You pretty much never see it in a negligence complaint, but you will see it for outrageous and egregious conduct with like intentional torts, for example. An example of compensatory and punitive damages is the O.J. Simpson case. So this examined, this case tried O.J. Simpson for the murder of his former wife and her friend. And I just find this fascinating. The civil court that tried this case ordered O.J. Simpson to pay $8.5 million in compensatory damages. And then on top of that, the court ordered O.J. Simpson to pay $25 million in punitive damages to the families. So it's not one or the other. If you pay punitive damages, you will also be paying compensatory damages, but it's really based upon how egregious the act was. Okay, and then the last one is injunctive relief. This is seldom found in tort law decisions. Often we see it more in civil rights cases, discrimination lawsuits, and it is a request to the court to require a defendant to stop doing an offensive act. So to stop discriminating, to not enforce a penalty or a sanction. So we'll talk more about injunctive relief later on. For negligence purposes, typically we're going to see monetary damages. And that is what we have for negligence.